our friends and viewers around the world. My name is Yinka Dansalami, and welcome to another episode of Know Your Rights on NABNTV, a program that provides you with general information about some of your constitutional rights in the United States. Today, we will continue with our discussion on immigration, particularly deportation. We will also answer some of your questions you sent to us from our previous show. We have in our studio today Esre Onaduan, an immigration criminal law attorney. Also in our show is Carla Prosper to answer some of your questions from our previous show. Welcome, ladies.
Thank you.
So now let's say that, I have now been released. I have my green card, but then, for some strange reason, I was convicted of a crime. So, and the immigration releases me now, and I have other means. In other words, I have a son, a daughter who now wants to file for me. Can I use that to stop the previous order of deportation?
So I just want to understand the question. So you were ordered deported.
Right.
You were detained.
Right.
You were released.
Right.
Somehow you got arrested and convicted of a crime.
No, the basis for that deportation was
something.
The basis for my original deportation was conviction of a crime. Okay.
Okay. And then you were ordered deported.
Yeah, I was ordered deported based on that conviction. So now I have a son or daughter, who now wants to file for me.
That person just became of age.
Right, yes. So can I use that to stop that deportation?
So, no. I mean, the thing is, the deportation order has been issued.
Yes.
Right? So that case is closed.
Right.
In order to even revisit that, you have to file or find somebody that will file a motion to reopen and reconsider. And depending on whether or not this child was available or eligible to file for you at the time that or before the deportation order was finalized will determine, your success. Basically, the relief had to have been eligible at the time that you were ordered deported. But if this child, became of age after the fact, I think it becomes a little more complicated.
So there is no way for me to now reopen that deportation?
Well,
for the court to reopen and reconsider it?
It depends. It's really, really fact specific because we don't know what the crime is. Yeah. We don't know when the removal order took place. Because usually, if, as Esre said, you could request to have a case reopened. There are certain time limits.
Yeah.
But if you're not successful in that, there's also a waiver called the I-212 if you're removed from the United States. And it's a permission to enter after an order of removal. It's called the I-212. You have to prove equities, ties to the United States. So this person may be eligible for it. But in the scenario you're also presenting, it seems that the children are adults.
Yes. And
adult children cannot file a waiver for crimes, nor could they file a waiver for unlawful presence. So we'd have to find out if this individual has U.S. citizen permanent resident parents or a spouse.
So is it possible for me that what if I reopen the basis itself, meaning the criminal conviction itself? So can I go to criminal court, reopen that criminal conviction, and what if that criminal conviction is now thrown out? So can I come back to our ICEIs and then say, you know what? This is the basis, for the removal. Can you now, reconsider, your basis for my removal?
So there's a 3-step, I would say a couple of steps. Quick answer is possibly. So what you're saying is that you found something wrong with your conviction.
Yes.
You got an attorney to file what's called a 440 motion,
yes,
right, in court to say that my conviction was wrong. Yes. Something was fundamentally wrong. The judge agrees with you.
Right.
The judge throws out the conviction.
Yes.
The issue is now you still have an open case. They vacate the conviction. No longer you have a conviction, but you have a pending criminal case. But the good thing is you don't have a conviction. Can you take that decision and write your motion to reopen and reconsider your deportation because now you no longer have the conviction that was the basis for your removal?
Right.
You can file that motion. But there's so many factual things that I would have to look at, or that we would have to examine before we can say that's definitely going to be successful.
So let me even carry it further. Let's say that after my 440 motion, court agrees with me, DA is not contesting it, and case get thrown out.
Mm-hmm.
So
dismissed.
Yeah, dismissed. Yeah. So the basis for my removal is based on this conviction that has now been removed, that has now been dismissed. Doesn't it mean that there is nothing for that deportation to actually stand on?
Yeah, the answer is, I would say yes.
You follow my question?
Yes, I understand. Yeah, you've gotten rid of your round of inadmissibility.
Yes, and that was the only thing on the NTA.
Yes.
Then the answer is
there's no basis, for the removal.
Yes. My concern is that judges may...
I'm sorry.
They don't automatically reopen a case, right?
So but now I have someone who's now going to, fight for me and then, petition for me.
Yeah. There is one thing I want to make very clear. I was lucky enough to have success with a motion to reopen and reconsider where the deportation was ordered pursuant to what we call a voluntary departure.
Right, okay.
So this woman was ordered, she agreed to leave, which is when you say to the court, I will leave on my own free will. However, she did not. She stayed for 10 plus years. We filed a motion to reopen and reconsider. And in our motion, we were able to say she has a U.S. citizen son who was of age at the time and in the U.S. military. So you see how it's so fact specific. And because of that, the motion was granted. And her proceedings were terminated. And then we were then able to file for her green card.
So we're going to go quickly to some of the questions, that we receive from our viewers. We'll be right back.
Accident? Don't talk to anyone before calling the Orhi Law Firm at 281-903-7333. Orhi Law Firm understands your injuries. We will see that you are fully compensated for them. Call the Orhi Law Firm for personal injuries, business issues, family immigration, and other legal matters. You will be very glad you did. Call the Orhi Law Firm at 281-903-7333 or visit us at www.theorhilawfirm.com. The Orhi Law Firm will fight for you.
Welcome back to our program, Know Your Right on NABNTV. So, Esther Okala, let me ask you this question. These are some of the questions we receive from our viewers. Under the existing law, can the issue of domestic violence affect an application for a permanent resident or citizenship? Either one of you.
I believe if you're the perpetrator of a domestic violence issue, yes. For citizenship, always remember the standard is good moral character in the last 5 years. So if you do have an arrest for domestic violence, that's gonna affect your good moral character finding. All right. Most likely you'll be found not to have good moral character. So you should wait if you have even an arrest or a conviction 5 years before you apply for citizenship from the date of the arrest, just to be safe. For your green card, depending on the conviction, and that's where we'll talk about that, because in some states, domestic violence is not only a crime, it's also in family court. So if it's a crime, it will affect your application, whether it's through discretion or needing a waiver. But if it's in family court, it's kind of a gray area. But domestic violence is very serious, it's very common, and immigration does look out for it. So yes, it can affect your application.
So Carla's absolutely right. So in New York and New Jersey, there are two avenues that they tackle domestic violence. One is the crime where you've been arrested and charged with particular issues that rise to the level of what we call domestic violence. And then in family court, even though it's not a formal arrest, they issue a restraining order. And that is considered a domestic violence issue. You do report to family court to handle that. So in criminal court, if your domestic violence charge gets dismissed in criminal court, but you still have that restraining order pending in family court, it still counts as a domestic violence offense. So you would have to take care of that one as well.
I see. So let me ask you, this is another question. I was married to a U.S. citizen for 3 years, and we have 3 kids and three children. My husband already filed for me, and we were expecting an interview date, but unfortunately, the husband died. So what happened to my petition?
The petition has now been terminated, unfortunately.
Is that what you call abandonment? Or is the word terminated?
Well, since the petitioner, no, I would say
the petitioner died.
He passed away,
yeah,
so it's terminated. The relationship is no longer there. However, there's relief. It's called an I-360 waiver, and there's timing issues, so you have to make sure you file that as soon as possible. And the I-360, it's a very great tool because it gives relief to widows or widowers who've recently lost their U.S. citizen or permanent resident spouses. And if your children are under 21, they can qualify under it. You will still have to prove that it was a bona fide marriage. So maybe a little more difficult and sensitive since your spouse is deceased. But there is an option for that.
So it doesn't mean that I'm out of luck.
No, it's not. You're not out of luck. There's recently been a lot of litigation about the timing of filing an I-360. So I would recommend this person speak with an attorney and make sure that she or he is within the time frame to file the I-360 waiver. Yeah, it's a very great tool to help people move on after such a loss.
So, Carla or Esri, I married a U.S. citizen, and my wife and we had our first interview with immigration. That interview was fine. But for some strange reason, immigration wants to re-interview us again. But before that time, my wife got picked up. She's in jail and she's going to be sentenced. So what happened to my petition?
It's tricky. One thing I want you to know is that your wife definitely cannot attend the second interview.
That's correct. Exactly.
There's no way that the corrections or whomever, wherever she's in jail, is going to bring her there. Right. There's also going to be an issue because when she filed for you, there's something called the affidavit of support, meaning she promised this government that she is financially stable enough to support yourself and herself, and that she will continue to do so. What
if I get somebody, to now file the affidavit for me?
Well, you can get a co-sponsor.
Yes.
Right.
Would that help?
However, I'm going to say that, and Carla, you can correct me if I'm wrong, you can ask them to waive her appearance at the interview and get a lot of documents to prove that your marriage is bona fide. Okay. So send mail back and forth to jail, visit her every 2 weeks, make sure you get copies of the visitor's log. I'm not saying that this is definite, but these are things that can assist you. Carla can probably.
But can they use the conviction against me?
No. So 2 things. I'd like to piggyback on what Esri said in the sense that when you're scheduled for a second interview, in Jersey and New York, we call them Stokes interviews because there's case law about it. It's a more intense interview. It's an interview where you'll usually be separated. You're going to ask to submit additional documents that you didn't submit in the first place. So you may try to request either that your spouse's appearance be waived, that he be excused, or with a lot of supporting documents. Or you may ask for a continuance if you know how long your spouse is going to be detained. I doubt those requests will be granted.
She will be sentenced to 2 years.
Okay, most likely, it could be held in abeyance, waiting for her release, or it'll be denied for abandonment because the petitioner never showed up.
So your best bet, I think, is you have to go. You still have to go to the interview. If your request for your spouse's presence be waived, then you do everything you can to prove that your marriage is legitimate, especially if you don't have any children yet, before you get there. So visits at the jail, make sure you request copies of the visit logs, put money in her commissary, allow her to be able to buy, holiday cards, sentimental cards, and send them to you. Keep the envelope with the stamp with her name on it.
Definitely attend the interview.
Visit with her family, spend time with her family.
If I attend the interview, immigration is not going to hold me, right? You're not going to hold me and say, okay, listen, we don't trust your first interview, so that's why we are scheduling the second interview.
That's a good question. And that's why a lot of people don't apply for benefits. I mean, if you're undocumented in the U.S., it's true. There's always a risk of you being detained or held. But let's be realistic. There's only so many resources that the government has. They are super powerful. If you are watching government, I'm scared of you. But there's only so many resources that they have. And if you are a person who is law-abiding and you don't have a removal order, and it's you need to advance. I've already
overstayed my visa.
Yes, but you need to advance your case, right? If you don't go, it's gonna die. That's the only certitude. If you don't go to this interview,
it'll definitely
the petition's over.
So will it be denied? Can it be denied without prejudice? If my wife.
It would probably be denied for abandonment, which is no prejudice. But if you have an officer who wants to use actually, you're right. I think it should be denied for abandonment because you're given a second opportunity to present the case. So it would be very unfair for them to use information from the first interview, which wasn't in depth, to deny your case.
Yeah. Well, what if the wife is in the hospital, terminally ill? What happened in that situation?
So remember, immigration is discretionary, right? That's a very, very humanitarian, sympathetic situation. So in my opinion, in my professional opinion, it would be treated completely different from somebody who is incarcerated. And then in the scenario you gave, the person was involved in drug trafficking. So you have to be clear that you're not also implicated in this as their spouse. So there are a lot of considerations. That person, I would tell them to go see an attorney.
So now let's say I marry a U.S. citizen and I have 2 children. Okay. So my wife is not the biological mother of those 2 children. So we were invited for an interview. Prior to the interview date, we receive a letter that the interview has been cancelled.
Yes.
So they will schedule me for another interview. I've been waiting now for almost 1.5 years.
Okay.
I haven't received any letter, for the re-interview. So do you think something is wrong with my application, or do you think immigration is after something, or what do you think?
I think you should follow up. I think that, immigration is human. They have a lot of cases. You should follow up at the consulate. Go on their website. There's different ways to contact them via email. And most consulates are pretty responsive. They'll give you a response within 48 hours,
but every time I go
hours.
to the website, I always receive pending.
The website isn't enough. You need to contact, you need to write a letter, you need to do an email, you need to make a phone call.
So you think maybe they probably forgot about me?
They may have forgotten about you. And then also, I'm a little concerned that you said the children are not biologically.
Right.
Are they minors?
Yeah, they are minors. They're
okay,
like 5 years and 6 years.
All right. Under immigration law, and this is a misconception sometimes, if the marriage takes place before the children are 18 years old, they are the stepchildren, which is the same as being the children for immigration purposes.
So they will not be interviewed. Those children will not be interviewed.
They won't be but they're included in the.
Yes.
Your spouse can petition for them.
Yes,
it's okay. Yeah.
Yeah, they were petitioned for. Yeah.
Oh, okay. So I thought that was an issue too.
No. Those 2 children were also petitioned for.
Okay.
So would they also be interviewed?
Yes. So put everybody's case number in the email, everybody's date of birth, your spouse's A number, his date of birth, his every information you have to verify your identification, and email them. They have calling systems. You have to get in touch. You are your best advocate. So
let me. I just want to be upfront with you also. You see, when I was coming to this country, I was married. So I did my divorce back home. Okay. So before I married this young lady. So what do you think? Do you think my foreign document, such as, the divorce paper, will affect the time that, they will call me for an interview?
If you do not provide USCIS with the divorce decree, my experience is they want the document, regardless of where it's from. The only time I've seen like a real delay is if, for example, they will send something called a request for evidence saying, I need this document. Some people don't respond or forget. Then what happens is that delays your case forever. So as long as you give them this document, just having the document doesn't affect your case.
Did they verify that
don't
document?
Give it to them.
Yes,
they
so
will.
that was going to be my point.
Yes.
The U.S. gives full faith and credit to properly filed divorces.
Yes.
So in some countries, I divorce thee is enough. But sometimes that's not enough. It has to be considered globally. It has to be properly registered. It has to have a certain seal. So make sure you do your divorce the proper way. The shortcut will affect you in the future because there's many people that applied for citizenship and then they realize that the divorce was improper. And in the U.S., it's illegal to be married to two people at the same time. It invalidates the marriage through which you got your green card and you're left with nothing.
So, but in terms of this verification, do they go to that country to verify? Is there a time that, has been allotted to each country for verification purposes?
So there's it's called the reciprocity schedule on the State Department's website. And what it does is it takes every country and it tells you how the document should look. This is what a police report should look like in Senegal. This is what a police report should look like in Nigeria. This is the seal the divorce should have in Nigeria. In this state, this is how the name of this is the officials. This is where you would get the document. So this is very, very well documented in the State Department. And they do have forensic teams which can validate your document.
So let me ask this question. I have one of those old green cards. Over 30 years ago. And I got convicted for burglary. Let me put it that way. And almost 25 years now. So, and actually at one point I was able to renew my old green card. I was able to renew it. Can I travel to Nigeria now if I want to?
We stated this before. Traveling does trigger your criminal convictions. Now,
so let me ask a question first. You were convicted of burglary, right?
Right.
And in New York?
Yes, in New York.
That would.
I was convicted a long time ago. This was almost 25 years. This conviction was almost erased.
It never goes away. That's what I'm saying. And the thing is, did you serve time?
No.
But you could have, right? So it's tricky, and it has to be you would have to sit with an attorney and go through all the specifics.
So I shouldn't travel to Nigeria?
No, I'm going to say no.
Yeah.
I filed for my green card. Why the green card is still pending, why my paper is still pending, I have to travel outside the country. I have visa to travel. I can go, I can come back, Would this affect me if I travel, or do I need some sort of permission for me to travel, even though I have a valid visa to travel?
Yes, the answer is you need permission to travel. Even though your application is pending, you cannot just leave the country. You have to apply for what we call advanced parole. And Carla can detail exactly how and where to make that application.
So if you have an application for your green card, an adjustment of status pending, a green card application pending, you can apply for an advanced parole, which is a permission to let you leave the United States. It also serves to notify immigration that you haven't abandoned your green card application, right? So once you get the advanced parole, you can travel outside of the United States. When you return, you'll be sent to secondary inspection. They'll just make sure your cases are still pending and allowed into the United States. Now, if you have a family emergency, this happens a lot. Somebody's deceased, somebody's ill, you have to travel. There are ways by calling the service center where you can schedule an appointment in person. Here it would be in Newark. In the city, it would be in Federal Plaza to request an advanced parole travel document. But if you do go for an advanced parole travel document, you have to have the proof of the emergency. So if it's a hospital letter, if it's a letter from the funeral home, and it has to be translated in English. So once you provide that, they'll verify it. And if everything's fine, you can get advanced parole the same day. But you have to make an appointment with immigration. But do not travel without it because you'll have abandoned your application for a green card and might not be able to re-enter the United States.
So what if I'm able to re-enter? I have a very valid visa to come in. My employer filed for me, and I was able to come back to the United States. So would that still affect my application?
Do you have an application for adjustment of status pending?
Yes, I do. Right.
Yes, it will.
So you're saying your application is pending. You traveled out and you had no problem coming back.
Exactly.
It will still affect you because your application will be deemed abandoned if you did not get advance parole document to travel first.
I see.
Yeah.
All right. You are suggesting that people who are faced with this kind of situation, they should try to seek for an attorney. What if the person has no money? This thing is very expensive.
Yeah.
So what should that person do? What should I do if I don't have any money? That I can pay an attorney. We're talking in terms of thousands of dollars. So what should I do?
There are options, and like anything that is free or cost efficient, it's very limited. So if you find yourself before an immigration judge, sometimes the court will give you a list of pro bono attorneys. Pro bono means free. You don't pay the attorney. You can go through the list. You will have to call each one and see if they want to take your case. If you are detained, and sometimes this doesn't make sense to me. If you're detained and they give you the list of pro bono attorneys, sometimes it's very hard for you to make those phone calls. Mm-hmm. So it's important to get that list to your family members and have your family members make the phone calls. There are also different organizations. One I know is American Friends. They're very good at dealing with asylum cases and other complex immigration issues. There is the Legal Aid Society. They take immigration cases. And this is something that most people don't know. Law schools in New York and New Jersey, around the country, usually have what's called an immigration clinic. And the way that works is you have an immigration attorney that is a professor, and they supervise third-year law students. They train them to do immigration work. And so you can go to the law school, ask for their immigration clinic, and if they take your case, they will represent you just the way an immigration attorney would do in immigration court for free.
Also, if you are a person of limited means, do not wait for the last minute. These places have wait lists. They may not take your case. They're not required to take your case. So you're going to have to do additional legwork. But you know this already, right? Because that's how it is. Sometimes you have to wait and take different options if you don't have the money to pay for it.
Thank you very much, lady. Thank you very much.
Thank you for having us.
It was a pleasure.
So we hope to see you again.
Thank you.
Yes.
Thank you very much. Thank you for watching Know Your Right on NABNTV. We hope that you find this program very informative. We will be on the air every other week. This will give you an opportunity to send us any questions that you may have, and we'll plan to address those questions during our upcoming show. During the next, we'd like to take this opportunity to appeal to you to advertise your products and be one of our sponsors so that we can continue to disseminate important information about the rights that you have under the United States Constitution and other federal and state laws. Information is power. We would like to equip you with sufficient information and to dispel any misinformation that may be in our community. Finally, please note that this program has not created any attorney-client relationship. If you have a legal matter or pending case, it is best to review all of the facts and circumstances of your particular situation with an attorney in order to determine the best course of action. You may contact any guest or any other attorney for further consultation if you wish. Neither NABNTV nor its host is liable for any consultation you may have with any guest of this show. We are merely providing general information to you. Thank you for watching us.
New Africa Broadcasting